Good morning, good evening, good afternoon, depending on when you are tuning in to this broadcast. My name is Kim Caputo. I am an attorney with the law firm of McAndrews, Mehalick, Connolly, Hulse and Ryan, and I practice in the special education space. I'm here with my colleague, Nancy Potter, to provide some quick and what we think is critically important information on a new piece of legislation that was signed into law in Pennsylvania in July by Governor Wolf. It is referred to as Act 66. It has two components, and we're hoping that after tuning in to this session, you will have some information to move forward in a positive way for your student and child with a disability. So I'd like to also introduce my colleague, Nancy Potter, and give her a chance to share some information about herself with you.
Hi, thanks so much, Kim, for doing this with me today. As Kim said, I'm an attorney at McAndrews as well. I am in our Pittsburgh office where I serve families all over the Commonwealth on K through 12 issues, particularly around special education. I also work with families in post-secondary education. So whether that is transitioning out of high school into a community program, a community college, or a four-year university, all the way beyond into PhD programs, medical school, representing students in a variety of civil rights matters in those areas as well.
So let's jump into what Act 66 is. As I said, there are two components. I'm going to share with you component one. Nancy's going to share with you component two. Component one speaks to a parent sole decision to retain a child, a repeat year, a do-over year. What does that mean? That means for any child attending a parochial, private, public, or approved private school in the state of Pennsylvania for September 2021, a parent has the ability to say, pump the brakes, stop. I want my child to have a retained year in 21-22 so that they are not moving on to the next grade. And this is directly as a result of COVID-19 and the impacts that it had with regard to how school was delivered, how education was delivered this past school year. What's important about exercising this right? It must be done in writing. We're going to talk later about the form, but it must be done in writing on or before July 15th by a parent giving specific notification to their school district. And again, this right is not something that parents previously had. Prior to Act 66, parents could approach a district to say, we believe our child should be retained, but ultimately the decision was the school district's to make. And if the school district did not agree, parents did not have the ability or a mechanism to challenge that. Now it is strictly a parent decision for next year only. Nancy, you want to tell us a little bit about the second component?
Great, thanks you so much, Kim. The second component of this only applies to students who have IEPs and turn 21 during the 2020-2021 school year. So those students typically would have aged out or graduated from their education program this school year. That means that they probably would have continued with extended school year services through this summer, but at that point, any programs or services they were receiving from their district would end. What the law says is for those students, and those students only, they may elect to stay an additional year until they are age 22. What that means, again, it's only for our students who turned 21 this past school year, who will turn 22 during this school year, may have an additional year of schooling all the way through this school year and all the way through the extended school year of 2022 programming. And then at that point, they can graduate and move on to their post-secondary life. It's important to note, first of all, that many of these families, your student may be in a program outside the district. And even if that's the case, where you may be thinking to yourself, we're already outside of the K-12 school year structure. My student's not in a grade. How can they repeat a grade? It's not really for those students about repeating a grade. It's about getting an additional year of education, programs, supports, and services all the way through age 22, which, as we were researching this law, Kim and I have been following it from its inception. I found out that, in fact, there are some states where students receive special education through age 22, like Arizona. So this is a creative solution that our states come up with around COVID, but there are students this age group who are receiving services under the IDEA through age 22 in other states as well. So now we're going to talk a little bit about what are some of the frequently asked questions we've heard. Our goal today was just to give you an overview of the law, address some of these questions in a way that will be helpful to all of you quickly as you're making this decision, because as Kim said, you must get these forms signed by July 15th and into your school district. So the first question, Kim, we're hearing from a lot of families is, okay, I understand this is a parent decision. This isn't an IEP team decision. So I need to decide whether or not retention would work for my child or is the right decision for my student. What are some factors in making that determination, and how do I decide if this is right for my child?
It's a great question. So let's start in our thought process about the world before COVID. In the world before COVID, there was a lot of research done. Research by the National Psychologists Association. You can find this research on the Pennsylvania Department of Education website. You can Google it, student impacts with retention. A lot of this research pointed to the conclusion that retention had drawbacks. It had drawbacks socially. It had drawbacks emotionally. Now, what's interesting about the research is it looked at retention in one bucket. But in the second bucket, it looked at this concept known as social promotion, which is moving a child along to the next grade based on his or her age so that he or she would be educated next to shoulder with kids of a similar age. And when the researchers looked at social promotion versus retention, again, they found definite negatives for some kids with this idea of retention. What were some of those negatives? Kids felt not great about themselves because they were being held back, left back, and they were watching their peers move on without them. Some individuals raised concerns about retention being nothing different the second time around. That particularly for students with IEPs, whose education is highly individualized, simply repeating a grade is not the same as looking at the student's individual needs through his or her IEP. That is the world pre-COVID. And that's certainly research that parents should take a look at if they are concerned about that. Post-COVID, however, we are in a slightly different situation. None of the research was done in the context of students who were not in school, students who were receiving their education 100% through a computer screen, and doing an analysis of, okay, for those students, what are the outcomes with regard to retention? And we are in this new world right now with that kind of decision making having to happen right now. And so while I do think research is always important and knowing what's out there, at the end of the day, parents know their children. And I would submit that a way to think about it is, all right, here we are in July of 2021. What did this past school year look like for my child? For example, was there any face-to-face instruction? Some districts had kids come back for 2, 3, 4, sometimes even 5 days. Was that successful for your child? What did your child struggle with this year? Were there social struggles? Were there emotional struggles? Were there behavior regulation struggles? Did those happen mostly during virtual instruction, or did they carry over when the child returned to face-to-face instruction? If those answers are yes, then maybe that's something to think about in the we want to retain column. Something else to think about is, of course, academics. How did, at the end of the year, as of June 2021, is your child performing at the grade standard of the grade that he or she was in for the 2021 school year? So for a third grader, is he or she reading? For a fourth grader, is he or she reading and comprehending? Is he or she able to do single, double, triple digit, addition, subtraction? As kids get older, we're into fractions, we're into percentages. If the answers to a lot of these questions are no, 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 then maybe retention is the right thing, because that is academic content that's now going to be delivered face to face that might be more effective for your child. So those are some considerations that are academic, social, emotional. Then there are some additional kind of more nuanced considerations. So for example, this upcoming September, if your child moves on in grade, does that mean your child is changing buildings? So I talk about that. I think about that as transition with a small t. Is your child moving, for example, from an elementary to a middle school building, or from a middle school building to a high school building? Those transitions in and of themselves, putting aside academics and math, putting aside social interactions, the transition themselves are big transition. New building, new teachers, new roster, larger roster, more changes between classes. I just did a talk a couple days ago about the difference between an elementary school where a youngster spends pretty much the whole day in one room, the elementary classroom. And there's a cubby and there's a desk, and the cubby and the desk are attached to the child. And that's where he or she can put the backpack. That changes in middle school. Now we are traveling with the backpack and we have a locker, and there are 3 or 4 different teachers, and there's a bell schedule. So is your child ready for that? Before COVID, before elementary school age kids moved to middle school, in the spring, typically there were opportunities for those elementary school kids to take a little field trip to the middle school, and for the middle school kids to take a little field trip to the high school, so they could see, oh, this is a lunchroom. I'm going to have lunch at 10:30 in the morning. Usually that wasn't the case in elementary school. Sometimes that is the case in middle or high school. This is my locker. This is how I have to open my locker. Is your child ready for those types of changes? Or would a year back in the elementary school setting be of benefit? So those are the kinds of things that I would think about, and I would suggest that parents think about when making that retention decision. How about you, Nancy?
I think that makes a lot of sense. I mean, I always, again, pre-COVID, caution families when considering retention for number one, the social aspect, and number two, why get 1 year all over again of something that didn't work? But I think all the things that have made the post-COVID world different mean that some additional consideration needs to be given to those pieces. Something else that families of our capital T transition students have been asking is whether there are any collateral consequences for their students who may be preparing or already signed up to receive a waiver or assistance through the Office of Vocational Rehabilitation. And what we can tell you right now about that is that the Bureau for Special Education has committed to having interagency collaboration and conversations with the agencies that run all the other programs for our young adults transitioning out of K-12. Unfortunately, we don't at this point have any written guidance or public statements on that, but we believe that those are coming and that reassurances about how that will work are coming. In the meantime, we would encourage families, if your student is 21 and you're considering this additional year, you do have to make a decision by July 15th. So if we don't know more information by then, I would say go ahead and fill out the form. And then if it comes to a place where you have to make a decision between those transition services and staying on the extra year, then you can make that decision. With that in mind, Kim, can you think of a circumstance where a family might not want to keep a student in school through age 22?
So a student who is now 21, who has the right to return in September. I can really honestly only think of one situation, and that is the family has a plan for that child, either that's in place right now or in place for September, that is rock solid, which is something more than, well, we had a meeting and we all discussed this is what's going to happen. My daughter's going to be in a supported employment situation. She's going to have a job coach. She's going to do that 2 or 3 days a week. If there's a rock solid commitment to that, then maybe that is worth more in terms of that young lady's growth and development than returning to the brick and mortar schoolhouse. But I would be concerned about a parent's hope that that is what is going to happen, only to learn on July 16th that the supported employment at the local grocery store or farmer's market or office complex isn't as solid as that parent thought. And on July 16th, it's too late. The doorway back into that public school is now closed. It's closed and the door is locked. There's nothing in Act 66 that gives parents a way to reopen that door past July 15th. So if there is a plan that is actually committed with resources, names, dates, places, start date, parents have confirmed that, it's all still in place, nothing with COVID has changed that, then that might be something that the parent wants to proceed with as opposed to returning back into school in September. Similarly, if there is a post-secondary option, so a number of community colleges and colleges themselves have offices for students with disabilities, and they also have introductory non-matriculating courses that some kids with disabilities enroll to take. If that is still the path, if that was the decision in January, February, March, or April of 2021, and the family has moved forward with that, and the young adult is still feeling like he or she is ready to take that step, then maybe that is a situation where you don't return to the high school brick and mortar. But again, I would caution, because a lot of times in order to take advantage of that type of arrangement, there's an expectation, for example, that the young adult can travel back and forth to the community college, to the local university independently. And the plan was in the spring of 2021, as part of the IEP, that travel training was going to happen. Well, if that didn't happen, and if it's not happening now in ESY, then maybe that's a reason to go back to get those skills that are necessary to access that post-secondary plan. So it's really individual, student specific, but the strength of the plan for September and the commitment of resources and people to that plan would be a circumstance that I would think a family would want to consider.
Thank you. Some of our families are enrolled in what are called APSs, approved private schools. Kim, for those families, does this law apply the same as it does for families whose students receive their services inside the traditional public school?
That is a great question. And the Act 66 specifically says that, yes, it applies. So parents have the right to make this retention decision if their child is in approved private school. Parents have the right to say, for a 21-year-old who's in an approved private school, I want to take the Act 66 extra year. Now, that means there are some realities with that, and those realities have to do with limited seat capacity in these approved private schools. They were, for example, interviewing, right, and sending out letters of acceptance to kids well before Act 66 got passed. It just got passed in July. And so they might feel like, well, wait a minute, we have a capacity problem because we only have a certain number of seats. What we know from connecting with the Pennsylvania Department of Education Bureau of Special Education is that the approved private schools are going to be supported by PDE and the Bureau of Special Education if they are encountering a capacity challenge. We don't know, because it wasn't information that was shared with us, what that support is going to look like. My best advice is July 15th comes and goes, and that door is locked. So make the decision. The decision goes to the local school district, and have the conversation with the approved private school. But your LEA, your local educational agent, is the public school or the charter school that was involved in the initial placement of your child in that private school. And so you should be connecting, it's like a triangle, parents, LEA, and the private school, all triangling, around this parent decision of we're staying the extra year as a 21-year-old, or we want to be retained. But at the end of the day, I think it's going to be something, that capacity is going to be something that's got to get worked out between PDE, the APS, and the LEA. I don't think it should be a barrier to a parent making a choice.
I agree completely. And then while we have, various individual questions that we're helping our clients through, another kind of bucket of questions that we're getting is, how does an extra year, either through retention or as a 21-year-old opting to stay through next school year, how does that affect a student's right to compensatory education for FAPE that has been missed, last year or even before that? And my thinking was, first of all, Act 66 does not address compensatory education. It does not say that this is to be a substitute. It does not use it as a link. It doesn't even mention the words compensatory education in the bill itself. So, I think that families should continue, if they believe that they're entitled to comp ed, to seek that. And of course, every comp ed decision is highly individualized. But I don't think that families should, make a decision about whether or not to sign the form on July 15th based on whether or not they believe they may also be entitled to some compensatory education. What do you think about that, Kim?
I completely agree. It would be wonderful if it were possible to keep each of those concepts completely separate. And I just, I don't think, I think there will be situations where that's possible, but I also think there will be situations where there's a little bit of crossover between a potential compensatory education claim and a decision to retain or stay on beyond the age of 21. What I would urge is, this is about July 15th and a deadline. If a family has data-driven reasons to want to take advantage of an extra year for a 21-year-old or a repeat of a grade for September, there's a short time to act. Do that, make your decision. If you think that your child didn't get what he or she needed, either during the COVID educational time frame or beforehand, that might be something you want to reach out to us about. I sometimes say there are no better eyes on a child than a parent's eyes. That being said, lawyers and education lawyers have sometimes a different set of eyes on the very same set of facts and the very same IEPs that parents have looked at year after year. And we might be able to give you some insights to kind of chew on and consider. This is, it's a challenging time. There is a tremendous amount on parents' plates. We know that. We knew that last summer when we would do sessions about COVID education. And now we're just adding one more thing, this Act 66 form. And so I'll close by saying, reach out to us. We are here to help. As a parent, as a foster parent, as a grandparent, maybe raising children, you are not in this alone. It feels overwhelming. We know this. We get calls today on Act 66, yesterday on extended school year, tomorrow on both things. We know there is a lot going on. If you are feeling overwhelmed, one, that's completely normal. It's justified. We get it. But know that we are here to help. Do not be concerned. Some families get concerned about lawyers and what's that going to mean and what are the fees we're going to have to pay. We have a structure in our firm. We absolutely believe in empowering parents. The way we empower parents is by sitting with them and giving them consultative, good information and good pathways forward. That is a no-cost activity. So reach out to us if you're feeling overwhelmed. On this form issue, I said I was going to close, but now I'm not going to close. I'm going to reopen it again. On the form issue, almost every district now on their website has something about, it's going to be Act 66. It might say Act 66 COVID retention. Go to your district's website. You should be prompted directly to the form, and you will be given information as to where that form has to be submitted. So then I'll close.
Thank you so much, Kim, for joining me today. And thanks to all of you for joining us to learn more about this important topic. We would love, if you are not already, to go ahead and click below here to follow our YouTube page. We have lots of videos, some very short, some very long and in depth, to provide help and assistance to families. And just as Kim said, because our ultimate goal is to empower families, empower parents and students to advocate for what they need and what the law says they're supposed to be getting. So You can reach me in our Pittsburgh office at 412-313-5510. And you can reach Kim at 215-344-1476. We are on either side of the state, though I like to say McAndrews is one big office with really long hallways because we get to collaborate on things like this to serve our clients the best way we can. So thanks so much for joining us. Good luck. And if you have questions about Act 66 or anything else facing your students' education, please reach out and let us be of assistance. Bye.
Take care, everyone. Have a safe rest of the summer.